to determine when it is justified to use armed force. That gets lost beginning with Grotius. And it finally reaches the kind of heyday, I think, when we come to the sorts of situations that lie behind the creation of the International Commission on State Sovereignty and their report, Responsibility to Protect, because the end result of the Grotian-Westphalian conception was that somebody who is the ruler within the framework of the sovereign territory can do anything he damn well pleases there, and it's nobody else's business. And that is just wrong, you see. So we lost something in moving to that conception. Excuse me while I scroll forward here. This is supposed to be a session on just cause, and I've so far mainly been talking about sovereign authority. So now let me get to that part in this written text where I do talk specifically about just cause. Part of what the sovereign must do to discharge his responsibility for the common good is to judge which issues justify resort to armed force. That's why in classic just war reasoning, just cause comes after the requirement of sovereign authority. Classic just war language signals this explicitly in linking the determination of just cause and the authorization of force to the action of a judge. This is the terminology that is actually used by the canonists. The sovereign is a judge, and that means he has a responsibility to make a judgment in these matters. It's not really all that clear-cut in many cases. What, from this perspective, constitutes a just cause for a resort to armed force on behalf of the good of the community? Aquinas' summary statement, drawn from Augustine, identifies two such cases. It avenges wrong when a nation or state has to be punished for refusing to make amends for the wrongs inflicted by its subjects or to restore what has been seized unjustly, and thus a just cause for use of armed force exists when there is an unanswered need for punishment and or restitution. Now, anybody in the current environment would say, well, what about self-defense? The permissibility of self-defense was simply assumed on this construal, but it is not a right of everyone to act on behalf of the political community in self-defense, and the political community has a further right, that is, the right of acting after the need for defense is over. The language that was used and that became normative was, it is permissible for anyone to wage war in self-defense or to protect property, nor is this properly called war, Latin bellum, but rather defense, Latin defensio, two different things. One may lawfully fight back on the spot, and the language, the Latin is incontinenti, before he has turned his attention to other matters. That is, private individuals and princes both have the right to use armed force in defense when the need is right there. But what about afterwards? Only then does the sovereign have a different kind of responsibility, that is, for setting right the disordering of justice and peace. And that's what classic just war tradition really addresses, the need for the setting right of these lost or damaged goods. When one begins to think about just cause for the use of armed force from the perspective of the highest political leadership and its responsibility for the public good, several considerations appear. The problem may not be the absence of justifying causes, but for resort to force, but in fact, their multiplicity. There may be a lot of them, so that the problem of leadership becomes one of judging where to strike the balance. While persons in the highest political authority have their first responsibility to their own political community, they also clearly have a responsibility to what we might call the community of such communities, whose overall welfare is necessary for that of one's own community. Further, where the use of force is concerned, there are responsibilities toward the members of the community towards which that force is directed, but they're not the same as the responsibilities that one has towards one's own community. Universal conceptions of right bear on how each of these responsibilities is understood. But at the same time, the nature of political responsibility imposes a hierarchy on these various kinds of responsibility. On this, there is striking coincidence of a sort not often seen between political realism and the natural law conception of the hierarchy of preferences imposed by nature. The needs of one's community come first in consideration, and then there is a graded hierarchy following from that. With the implications of this perspective in mind, what are the various ways of framing the possibility of just cause for use of armed force typically found in the current debate? I don't want to talk about all of them, but I'll mention two in particular. The first is the idea that force is only justifiable in self-defense against armed attack. And secondly, I'll talk about the idea that the use of force is justifiable for humanitarian intervention. Historically, the defense requirement is a resort to force, is a justification for resort to force only in a backhanded way. The first aim of this, as it appears historically in both law and moral thought, is to prevent resort to force, not justify it. So if we look back at the Kellogg-Briand Pact of 1928, we find that the language of the treaty is about states renouncing the right to use armed force in settlement of disputes with one another, and it's only in Secretary of State Kellogg's private correspondence that we see that this isn't in fact intended to take away the traditional right of self-defense. Similarly, in Article 2 of the UN Charter, the language of the Kellogg-Briand Pact is picked up again, and it's not until Article 51 that we find the language that allows self-defense, individual and collective self-defense. And even then, exactly what is allowed remains subject to interpretation, and I would suggest that properly it needs to be. For example, Israel's preemptive attack in the '67 war, which Michael mentioned earlier, was denounced by the de Gaulle government as illegal because there had not yet been an armed attack. There was a spirited debate in this country, to change to another topic, during the high years of nuclear uncertainty between the US and the USSR over a launch on warning policy, or whether instead to strike first or to reserve our nuclear response to a Soviet attack until the missiles had landed. This morning panel on preemption, as well as a number of recent books and the ongoing debate over the 2003 invasion of Iraq, show that this issue is still in debate and still important. This rather tangled history shows that the idea of defense as just cause is not as simple as many would claim it is at first blush. It's also problematic, defense is, because of how this conception has become stretched in contemporary usage to cover what are clearly other rationales for justified use of armed force. Deterrence, which is really retaliation and punishment, response to an armed attack in progress, the language that was used both to justify Britain's action in the Falklands and to justify the removal of Iraq from Kuwait after the invasion in 1990. In classic just war terms, these were recovery of what has been wrongly taken. In any case, it's restoration of justice. The upshot is that whether a state may rightly resort to armed force in a given context turns out to be finally a matter of responsible statecraft. And just war thinking historically had to do with this, but I suggest that a good deal of contemporary just war thinking, by ignoring the application of the reasoning to statecraft, punts and doesn't really deal with it. Well, I'm running out of time, so I won't talk about the issue of human rights. I do want to say a few words in conclusion about the issue of the use of force in responding to actions by non-state actors. Armed conflicts involving non-state actors have become the principal face of contemporary warfare. And the assumptions, this is in contrast to both the assumptions that guided the shaping of much of positive international law and the assumptions on which a lot of contemporary just war thinking have focused, namely that modern war would be a kind of World War III involving nuclear holocaust. But the real problems with warfare focused on non-state actors are very different. Such actors are often very hard to get at. They often define their cause in such a way as to erase distinctions between combatants and non-combatants and engage in actions that directly target non-combatants as a preferred means of fighting. They don't wear distinctive marks, thanks to the 1977 Protocol 1, and they hide among civilians so as to do harm to those civilians, again, thanks to Protocol 1. Their command structure is dispersed so that responsibility for particular actions is difficult or impossible to trace, and so on. So the kinds of considerations that Michael Walzer was putting before us at lunch turn out to have some other ramifications also, because the playing field is not in fact level. The legal playing field is not in fact level between regular militaries and non-state actors, but not level in the way that other people would probably say, level in a different way from what others would say. This kind of fighting is in direct challenge to both the provisions of international law and conclusions of just war reasoning. Moreover, responding effectively to it may involve one's own armed forces in kinds of action seriously in tension with both or in direct contradiction. And again, the matter of the not having a level playing field. Members of regular national armed forces are, because of the way such forces are structured, the records kept and so on, able to be held to a stricter standard of behavior than the people they're fighting against, who, because of the structure of their bodies, are able to dodge being held responsible. I will just conclude by noting that for centuries, just war tradition maintained a strong bias against the kind of irregular non-state fighting groups that we find in contemporary asymmetric warfare. Their leaders were, in first place, understood as not having the right to authorize the use of armed force, and so by definition they were fighting unjustly. Accordingly, their taking arms meant that there was no distinction between them and criminal bands, for both operated outside the law. Second, their means of fighting, even in the pre-modern era, tended to increase the level of death and destruction in war because of the weapons they used, the fact that no quarter was given and no prisoners taken in such war, and the larger number of people that might take arms in popular uprisings. And so I suggest that these issues also need to be taken account of or at least need to be subject to reflection in taking account of whether there is a justifying cause in dealing with attacks from such groups. Thank you.
Thank you all very, very much. We have good time for questions. I am going to assert moderator privilege and begin those and ask two of my own. I think they're pretty small or quick ones, and they're both to Professor McMahon and perhaps Professor Roden as well. The first one, I think, again, is a quick one, and they're both for clarification, just to try to understand what you're saying about just cause. Are there any other possible justifying reasons why somebody might kill somebody other than a physical threat being posed? So, for instance, like the threat of like cultural eradication. So, like think of China and Tibet. Like, okay, they're not in there necessarily going to kill the Tibetans, but they're going to occupy the country and educate them out of Tibetan culture, et cetera, arguably, right? Would that be the kind of thing that perhaps could be a just cause? The second question, and I think it's slightly related, but you don't have to try to relate them, goes to the second justification, which was the justification by necessity. And you use the language or distinction between justified and just, right? So you said, and if I got this right, I think this is what you said, we're justified in doing something, but we would be wronging those against whom we fight, okay? I have a question about this. wouldn't those against whom we fight become liable to our fighting against them if they're defending